Now the focus has been, especially as it relates to trial advocacy, on direct examination with our exchange with the witness. We ask questions, carefully crafted questions, we get our answers from our witnesses. It all goes in the line of how we want to present. But we're also learning another skill and talking about something else that happens in trial advocacy, which is objections. And specifically what I want to talk to you about today is responding to objections as the proponent. Nobody wants to have their question and answer, their examination, interrupted by objections. But if you embrace objections as an opportunity to respond, go back to your examination seamlessly, you can actually come out ahead of the game in front of your jury. So I like to use hearsay as the example. Hearsay is the biggest, baddest topic that we have in evidence. It's weeks of instructions, it's the most tested on the bar, but you can reduce hearsay to one of three reactions, one of three responses to keep that train going and get returned to your examination. So let's look at that. All of hearsay, all those 3 weeks of instruction, is invoked by 2 words by our opponent. We say, when you walked outside the building, what did Mr. Smith say to you? As soon as we hear those words, everyone's sensors goes off. What did Mr. Smith say to you? Oh, it's a hearsay statement. Objection, hearsay. 2 words, they invoke the whole rule. All those exceptions, all those definitions, they invoke the whole rule. Objection, hearsay. We suggest you to respond in 3 ways, and think about it conceptually in 3 ways. Don't get panicky and nervous when you're thinking about everything you've learned in hearsay. Think about it, it's going to take one of 3 paths. That is, it's not hearsay because, it's non-hearsay because, an exception applies specifically. One of those 3 things is going to be the beginning of your answer. It's not hearsay, and you pull apart the definition of hearsay. Probably the most important definition that you learn all in law school. An out-of-court statement offered for the truth of the matter asserted. So when I respond in that first way, objection, hearsay. Your Honor, this is not hearsay. It's not offered for the truth of the matter asserted. Instead, it's offered for its effect on the hearer. I pull apart some part of that definition that I know. Objection, hearsay. Your Honor, this is not hearsay. It's not a statement. Your Honor, this is not hearsay. It's not offered for the truth of the matter asserted. It's a verbal act. Your Honor, this is not hearsay. It's not offered for the truth of the matter asserted. It's offered for impeachment. Any one of those definitional reasons, I start out with that. It is not hearsay because. The second one, it is non-hearsay. The rule makers have carved out parts of the rules where they just say, it doesn't count. It's admissible. It's coming in anyway. So what we do, the way we think about it is that's our second response. Objection, hearsay. Your Honor, this is non-hearsay under a specific rule. I'm eliciting the admission from a witness, and I'm the party opponent. It's in under 801 D2A. Even if we don't remember the rule number, you can get to those parts that are non-hearsay defined. So that's 2 examples. It's not hearsay because, it's non-hearsay because. The last one is an exception. Objection, hearsay. Your Honor, an exception applies. Specifically, this is an excited utterance under 803.2, and you may go to sidebar or you may have further discussion about whether that exception applies. But really, if you think about it, responding to the biggest, baddest objection that can come up during your direct examination is hearsay. And if you reduce that reaction, that as the proponent, I'm not going to look at my opponent, I'm going to look at the judge and say one of 3 things. It's not hearsay, it's non-hearsay, or an exception applies.